I think we'll all agree, everyone on the panel, I think everyone in the audience, and I think you will agree, that if we had it in writing, we wouldn't be here today because everyone would know exactly what we're talking about.
Sure.
Yeah, know what we're talking about.
I have no problem with that.
And I created out of whole cloth a proposed form that the executive committee did not approve, but at least there's something out there for district chairs to look at, and JPs and countywide elected officials to look at. So I do want to come back though to the same subsidiary question, which is this. Couldn't the county committee rely on the lack of a writing when they considered this in February 2023? Isn't that a proper way to handle things under this rule that we're talking about, 4A?
I don't think so, because I think that they did not have, back to a lawyer term, they did not have jurisdiction at that point. That the authority to do that was at the organizational meeting held in June of 2022 by the clear reading of that rule, the clear reading. And even if there was a motion and there wasn't, to strike them or to, it was just a decision, we're going to remove them, okay? So there was, I don't think you can wait 8 months to reconsider a motion, okay? And it certainly wasn't moved by someone who had voted on the prevailing side. So I don't want to get too deep into parliamentary procedure. I was just trying to look at the plain reading of the rules, okay?
This is my only chance to vex you, so I'm going to vex you.
And I think our rules, and I say challenge y'all to this, have to be where non-lawyers understand what it says. And it should say what it means, and we should follow that meaning. We shouldn't have to lawyer these rules to death, okay? I have all due respect to a fellow lawyer, okay? There you go.
So one follow-up, if I may, Madam Chairman. So section 6 of the district rules, vacancies. District committee vacancies shall be filled by the body that originally elected the member. The body that elects the member apparently is not defined, but is assumed. And if the county committee assumed that that body was the county committee,
It would be wrong.
So that's a clarification you're asking us to make, whether that's wrong, whether you need to get a clarification, but your assumption is that that means the electorate of Saline County. If the county committee relied on that rule, and that it was the county committee that fills all vacancies, because it is a county committee election under 4A, it's a county committee election.
Yes.
So if the county committee relied on that, they did have authority in February to do what they did. Is that right?
Well, under their interpretation, I'm not sure that it would be correct, okay? Okay.
So we need to figure that out.
Because all you have to do is look at all 9 of the groupings, all 9 of those that serve on the committee, the district committee, and the county committee can't elect the vacancy of a vice chairman of the Young Republicans. It has to go back to the Young Republicans. It can't, the county committee can't go back to the Women Republicans and elect that replacement. So the only ones the county committee can elect are those 15 in our case. If the county chairman for some reason resigns, or if the district committee man or district committee woman resigns, the county committee can do it. I think that, once again, our rules are follow at different stages of committees. If the legislators are all members of the state committee. If one of them resigns, no one can replace them until someone is elected to serve in that position again. That is clearly akin to the position to the district committee. There has to be an election for those elected officials. The body that placed them on the committee is the body, the general election, if you will, and not the county committee. The county committee never okays that position. It's an automatic position.
It's But it's only automatic if it's claimed in writing at the time of filing.
That's correct, that's correct, that's correct. I'm not denying that, I totally agree with
And
that.
I'm trying.
But I think those seats had to sit vacant once they were not claimed.
So I'm trying to,
No.
Sat back, I think, for years.
I'm trying to get to the point of, and I literally, I just want to make sure that I don't come back with something I haven't discussed with you, because you're the moving party, you're also a lawyer, and you know wherever you speak, and you're far better versed than I. I just want to make sure that for purposes of everyone listening and for between you and me, we understand this. So the general rule for judges reviewing committees is that we should make a decision on something that we don't have to decide for the issue before us. And so the question is that the issue we were discussing in section 6, the body that originally elected the member, that's an unanswered question that might be before us. But would you agree that if the county committee said, because there was no written claiming, the election is by the county committee, and it doesn't matter what our interpretation of quote the body in section 6 is, because there's no issue, because there was no written claiming at the time of filing?
I would not agree with that. I go with the specific reading of that rule that says they can only be filled at the organizational meeting. Now, let me take you a step further. If the county committee of June 2022 had filled those positions that were unclaimed, and those individuals, some had resigned, then the county committee of February 2023 could have filled those vacancies because the vacancies had been filled by the county committee.